All right. So we are really lucky today to be joined by Freddie Johnson from Prairie Creek and Jeff Masten from Landmatters and the newly emerging Bluestem Conservation Cemetery. Freddie and Jeff, would you like to introduce yourselves and walk us through conservation easements?
Sure. Freddie, you want to go first?
Sure. My name is Freddie Johnson. I am the founder, one of the founders of a nonprofit called Conservation Burial Inc., which is the operator of Prairie Creek Conservation Cemetery, which is a joint project between our nonprofit and Alachua Conservation Trust, a nonprofit land trust in Gainesville or Alachua County, Gainesville, Florida. Also, one of the founding members of Conservation Burial Alliance. And thanks for having me here. And it's good to see everyone.
So I'm Jeff Masten. I guess, well, welcome to kind of the presentation. Freddie and I both bring kind of practical experience working with conservation easements. He has a lot of experience with, and this will come out later in the presentation, with actually operating a conservation cemetery under an easement. And I have a lot of experience in writing, drafting easements, stewarding, monitoring easements with almost 2 decades working with land trusts. So I bring a little bit of that perspective to it, but also I'm kind of in the process, Heidi and I are in the process of building a conservation burial ground. So these are things that are kind of actively on our mind about what do we want in our easement? How is that going to work? And so there's a little bit of kind of newness to kind of perspective, and I'm kind of looking at this from both sides. What would I as a cemeterian want, and what would a land trust look at this same issue with, and how do you kind of negotiate that point? So we're looking forward to kind of this presentation, and let's kick it off. Next.
Hold on, sorry. I got excited. All right.
All right.
Are we
So
ready?
while we're waiting on that, I will.
Are you guys able to see? Are we screen sharing?
Nope.
Okay.
Nope, not yet.
Hang on.
So I'll kick this off with the first half and kind of go through some of the nice boring parts of conservation easements. And then Freddie will talk more about the practical side of his experience working with conservation easements. And at the end, we'll have a long period where we can go through the aspects of all of your questions. We are not lawyers. I'm just going to say this because this is what I say all the time as a land trust person. Not as I'm not a lawyer, so therefore you need legal advice, you talk to a lawyer who has experience with conservation easements. But we can give you a lot of practical sense for understanding just the kind of the kind of the ABCs, or the 1, 2, 3s of conservation easements and how this works. Okay, next. So I wanted to point out that on the CBA website, there is a tool that's available to you all, and this is how you get there. It says you go to the CBA website, you go under the Land Trust tab, and then under that the Working Together tab, and you'll see this document is there, and it's a great primer for the relationships with conservation easements. So it was drafted by Lee Webster, I guess it was about a year and a half ago. I had some kind of editorial part in it, but it's mainly Lee. It's really it's very detailed, and so it's going to go through stuff that we're not even going to talk about today. So this is, and the whole reason why we made this was exactly for this purpose, which was, okay, I'm thinking about conservation easements. I'm not sure what they are, or how they work, or what the pieces are, or how it's relevant to my burial ground. What are the details that I need to be thinking about? Well, that's what this document's all about. So hopefully you can find that. And if not, let us know, and we can get you, send you a link or something like that. Okay, the next. So kind of what is a conservation easement? So a voluntary legal agreement between a landowner and a qualified conservation organization. So in this case, where the landowner would be the cemetery. And it's not just a conservation organization that's a land trust, it could also be a public agency. In fact, some of the existing conservation cemeteries that exist today actually have conservation easements with local, county, some in cases local. It could be even a state entity that can hold that easement. So what it does is it permanently limits kind of certain uses of the land to protect its conservation values. So what does that mean in practical language? So it's a permanent deed that's placed on top of a piece of land between the landowner and the government or the land trust. Permanent, and its primary purpose is to protect the conservation values identified on the property. So that's it. That's the test of the conservation easement is how does it work in terms of its protection of the conservation values for that property. Everything that occurs on that property has to fit within that realm. I want to highlight again that it's permanent. So we, in the land trust world, we use the word perpetuity. In other words, it can't be undone and it lasts forever. And that's just important to know when you're thinking about decisions. We're not thinking about 10 years, we're thinking about 100 years. We're thinking beyond that in what we're thinking about. So we really have to be careful with the choices of language that we use. And Freddie pointed out two good points, that there needs to be harmony between the cemetery and the conservation tenets, and harmony of the conservation with the operations and strategies of running the conservation cemetery. And then lastly, conservation easements are used kind of for many purposes. Here today, we're really focusing on their interaction or their use with conservation cemeteries, but there's all kinds of conservation cemeteries that include things like farming and viewshed and water quality protection. Some of those pieces fit in these conservation easements that we'll be talking about, but is really focused on how do we protect the conservation values of this land that has a conservation cemetery operating on it. Okay, next. So factors to consider in developing a conservation include that both parties must be in agreement in the terms of the easement. So again, there's this kind of win-win outcome that you're really looking for. It's a negotiation. You're looking for common goals, find negotiating points that are important to both parties or individually to one. And then there are red lines. There are points of no, I can't do that, or no, I have to do that. And you need to kind of understand what those pieces are. For example, I'll give you an example of a red line. Many conservation easements don't allow for mining or digging within the easement themselves, but that's an inherent part of conservation cemeteries. So this is this intersection point that really has to be resolved and has to be kind of figured out, and it's just an ultimate necessity for it. Let's see. It's a long-term relationship that must last the test of time. So cemeteries are, really perpetual, and the cemetery organization needs to be built to be operating long into the future. Land trusts really kind of follow the same tenets. They talk about the conservation of their development and of an organization as being perpetual. So they also need to kind of be strong and sturdy organizations. So both organizations kind of really are fitting in the same space, and that relationship, once you sign an easement with whoever the receiver of the easement is, they will be attached to that property forever. So you really need kind of a strong and durable relationship, need to understand kind of how that works, and be open to the kind of collaborative approach and kind of a shared common value system. You know, with climate change coming, natural disasters, kind of neighboring land use changes, and these are all real conditions that ultimately impact land over time, and also impact what's on that land and what's living on that land. And the easement needs to be flexible enough to be able to kind of withstand all of these things that are going to be thrown at it over time, in the way it's built. The utilizing clear, concise language is a key attribute. Include exhibits and maps, further define the flexibility of the conservation easement, which then allows endless approaches to drafting the easement. Easements can be extremely complex, but I would recommend that you use simple language, simple principles by default to really kind of make, you want the description of the easement to be very clear and readable by all parties. Limit the complexity as much as possible. You know, a cemetery will need to operate under the conditions and of the easement, and the conservation organization is going to have to be able to monitor whatever it's said, whatever is stated in the document. And so it's not really valuable to have things that aren't that don't work in the favor of either being able to monitor in the future or being able to operate in the future. That's where simplicity really is so incredibly valuable. And lastly, you work with really good lawyers. It's worth finding experts in the field. It's worth finding people that can that do this work, do it professionally, know what they're talking about, and can really draft good, logical, simple language. I can't say that enough. I've experienced all different types of attorneys working on this, and it really comes back to bite you later on if the more complex you make it, and if the language is you're working with an attorney that's really not specializing in the field. So there's this term, the KISS principle: keep it simple, stupid, or keep it sweet and simple. Either way, that's kind of what I like to kind of use as my descriptor for how to operate in the, using easements. Okay, next slide. Okay, you're almost done with me. So this is, I'm going to get a little jargony here. It's a little bit of a complicated slide, but hopefully it will make sense when I'm done with it. So what an easement really does is it takes rights. And what we in the land trust world, we call this like the bundle of sticks. So imagine you're holding a bundle of sticks in your hand. You take one of those sticks out and you give them to someone else. You've kind of given one of your rights away. And so let me describe that a little bit further. So when you have land, you inherently have rights with your land. So I'm not going to list them all, but there's the right to own the land, the right to sell the land, the right to develop the land, the right to cut down trees, your mineral rights, your ability to dig. They're all the things that you inherently have that are allowed by law under your ownership of that land. What we're essentially talking about is taking some of those rights away and voluntarily giving those to a monitor, a conservation organization, or a governmental entity. And that's the essence of what the easement is. So for example, with the cemetery, you want to retain certain rights, right? You want the ability to operate your cemetery. You may want forest management, you want privacy, you want kind of the permitted activities that would be allowed for operating your cemetery. And of course, you want the ability to manage and operate that land to protect the conservation values. What you might have given away in the process is your ability to bury densely, right? So especially with conservation under the provisions of the Green Burial Council, that's what we're really ultimately talking about. Maybe I should have led with that. Is we're really talking about is meeting the standards that have been set by the Green Burial Council for kind of what is a conservation cemetery? How is it, what are the certifiable standards that have been set? And so the Green Burial Council has standards saying, 300 burials per acre is the max under the conservation cemetery certification standard. So if you can bury a traditional, or I shouldn't say traditional, a conventional cemetery can bury 1,000 to 1,200 plots per acre. So your municipal cemetery, conservation cemeteries bury at a fraction of that. So many of the conservation cemeteries really are burying about 100 per acre, but the Green Burial Council standard is set at 300. So that's an example of transferring rights. You're saying, I'm limiting myself to no more than 300 per acre. And that's something that's monitorable by another party. They can say, let me see your records and your map of your property and what your burial density is. Another example of rights you might give up, and there's lots. I'm not giving you all of them. I'm just giving you some of them, but there are like prohibiting certain activities. So you might limit your ability to subdivide the property in the future. You might prohibit the addition of structures, or a certain number of structures, or a certain square footage of structures. You might even say where burial cannot occur on the property, where there might be sensitive areas and stream buffers and things like that. So those, again, are rights that you've transferred to another organization as part of your conservation easement. That's the essence of kind of how it works. And as we all, I just want to kind of create two. There's these simple easements that you all have heard of. So maybe an access easement, the ability to have a driveway across someone else's land, or a power company has an easement across someone's land to put their power poles. So again, it's in that case, you're giving them the right to be able to do that. We're talking about similar things. They're just different purposes. And ultimately, at the end of the day, you want a win-win between both parties, happiness on both sides, and the ability for a sustainably operating conservation cemetery. So with that, we're going to move on to Freddie, who's going to talk about kind of more of the purposes and realities of conservation easements and how they work in practicality.
Thank you, Jeff. So as Jeff alluded to, my experience is limited. I have no expertise, hardly in anything, certainly not conservation easements, but I do have about now going on, I don't know, 13 years or so of some practical experience of sort of living with conservation easement for Prairie Creek Conservation Cemetery, which in and of itself is sort of a unique conservation easement in that, and Jeff also alluded to this, our partner, the Land Trust, Alachua Conservation Trust, which is a nonprofit, and our organization, which we don't use very much the name, but it's Conservation Burial Inc. And having basically what that's about is conservation burial solely, whereas a land trust is, they like that, but they're much more broad in trying to save land and manage it. And our organizations are coming together in partnership for the creation of Prairie Creek Conservation Cemetery, and that's what we do. However, since Alachua Conservation Trust owns virtually all the land, and I say virtually because a little bit of land that our organization owns is actually happened a few years ago out of operating and having availability to some private land that we could go in together and secure, which was a wonderful thing. And our organization paid for some of that land through of burial fees. But where I'm going with this is the landowner can't hold the conservation easement. And we, as a Conservation Burial Inc. organization, nonprofit, we can't hold it. So what happened was is the county, if you remember, Jeff said that was another possibility is government. The county wanted that land to be available to the public and was interested in buying that portion, which at the time was 78 acres. Now it's 93 acres, but because of the extra land we bought. So the conservation easement is between the landowner, Alachua Conservation Trust, and the county. And what we are, our responsibility is to act like, it's almost like, as far as we're concerned, it's with us too, because we pretty much operate the cemetery, our organization does. So it's a very creative thing. And Jeff had on one of his slides, win-win. Well, this turned out to be a win-win-win. I won't go, that's probably more detail than you wanted, but I just wanted to point out that it is kind of unique. I don't know at this point in time if there's another conservation burial ground that has a triad relationship like that. And Jeff has already made the point about, this is a permanent thing for perpetuity. So therefore, it really requires and asks for a lot of foresight and questions and collaboration between the parties that are creating this conservation easement. The other important part is that a conservation easement, in terms of, as Jeff said, the Green Burial Council actually requires, if you're going to call yourself a conservation burial ground with certification, you've got to have a conservation easement. If you're a member, if you want the Green Burial Council to acknowledge you as a conservation burial ground. And by the way, these terms, burial ground or cemetery, I treat them as interchangeable. Some people have preferences; they like to use one or the other. But as far as I can tell, they're interchangeable. But let's just say you didn't want to be a member of the Green Burial Council, and you didn't care whether you were certified as a conservation burial ground. Then I guess you could call yourself a conservation burial ground. But what's happening more and more is I can tell you that people are finding out and looking for the criteria that substantiates and confirms that you're not doing something that relates similar to greenwashing. They want to know, the public wants to know, and eventually, if you're doing everything, if you don't have a conservation easement and you think or want to call yourself a conservation burial ground, how are you going to assure? It's fine if you can assure that you're dealing with something a cemetery that should go on forever, and you're dealing with an ecosystem that you want to go on forever for the benefit of people, for the benefit of animals, for the benefit of the planet. So it's important enough to have the kind of protection, which as far as I know is the very best protection for land that exists. I mean, I don't know of anything stronger. Maybe Jeff can chime in here anytime and correct me on any of this. As I said, I'm not an overall expert, but as far as I know, it's the strongest way to protect that land. We can go next slide, which I've already talked to a good bit of this, but it is like amendments are difficult. There's a high bar for changing anything. The writing of a conservation burial ground, conservation easement, it's well worth asking lots of questions. And as Jeff said, having the right legal advice. There's also what I found at Prairie Creek Conservation Cemetery experience is going into a conservation easement oftentimes has a lot of cost associated with it that you have to do. It might be like one of the things we did early on is we tested water levels for the whole at that time 78 acres. And there's just, we had to go in and pay for surveying. There's a lot of upfront costs to figure out what your sort of starting place is in terms of the land, and how you confirm how the land is at the present time of your starting, so that you'll have a comparison basis of what you do is do no harm or actually enhance the land. See if I'm missing anything there. Conservation easements. Had a note. Oh yeah, the now versus when Prairie Creek started. I mean, we're a certified conservation burial ground. We were the 4th in the United States, but when we first started evaluating and researching and planning, it took us 3 years before we opened. So there was 3 years of every month meeting, a group meeting, a board meeting. And when we looked out there for information, there was only, at that time, there was only a couple conservation burial grounds or anything close to that. One, of course, you probably all know is Ramsey Creek Preserve, but they didn't have, at that time, I don't even think they had a conservation easement, or if they did, it was a very simple, basic one. And the point I want to make is, we knew we wanted to have a conservation burial ground. We found a great partner who knew all about conservation easements, but they had never, ever, ever heard of doing a conservation easement for a natural burial ground. So the expertise they had was about conservation easements. And we, who wanted to have this conservation burial ground, had no practical experience of how to match up what we needed with that conservation easement. So it was kind of a pioneering event, and amazingly, it has worked out remarkably well. Not perfect, but remarkably well. But once again, my point after that long and drawn out array of sentences is that there's a lot more to work with now. There's there's programs like this. There's a number of conservation easements associated out there with facilities. Probably around 20 now out there, I would think, or closing in on that. They're all going to be different. And that's part of the beauty, is that you can go in and see how for that particular geographical area, and for that particular, whether it be a land trust or organization whatever organizations that's starting or has started the conservation burial ground, you can see how they differ, and you can find different points that might be sort of jewels for whatever one that you eventually might be working on or are working on. So I encourage everybody, when you're a part of this process, to look around and take advantage of the collaboration that's out there and the examples that are out there. Next slide. So with us, as I've explained, sort of the relationships, this is what I can do, is I can kind of share some of the lessons learned. When we first started, and remember, this was like the relationship now between county and Alachua Conservation Trust, which is where the conservation technically was between those two parties. But then you've got this other, we just call ourselves Prairie Creek Conservation Cemetery now, but it's a separate nonprofit that has to honor the conservation easement, but we're not actually one of the parties in the conservation easement, except for we are mentioned in the conservation easement because of the burial ground there. And I think probably lesson learned for us, or me, or Prairie Creek, is that we had a lot of excitement and startup and Alachua Conservation Trust. Also, there were a lot of things going on at about the same time we opened. I would say one of the biggest lessons we've learned is to identify kind of 3 different timelines. There's the timeline when you're building the conservation easement, you're creating it and developing it. And as already mentioned, that requires a lot of attention and bring in the parties, any any affiliated parties or anyone that might have some expertise, let the questions be asked and find that harmony. And then once you find the harmony, next challenge is to have clarity in explaining what you've all agreed upon. So that's kind of one phase, is get it as good as you can from the beginning and do it right. The next phase is actually when you open and you initiate it. And here's where, if we had it to do over again, we would have probably spent more time. That is when, before you actually start engaging with this conservation easement, everybody needs to review it and understand it well with lots of questions, and make sure that when you initiate it and start process and management and operations, that you're in tune with it, and everyone needs to be in tune with it. And then I would say the third phase is periodically, whatever timeline makes sense for your organization, but periodically the conservation easement needs to be reviewed, so that to remind everybody of what you're dealing with and sort of check yourself with it. And one part of that is anytime, regardless of that review, is anytime anybody does something different, or if you have new board members come in or new staff come in, is to take the time to go over the conservation easement. And doing those three things right and continuing that process is I think one of the big lessons. Like we have at Prairie Creek now, we have regular communication, scheduled what we call cross-staff meetings with Alachua Conservation Trust and our staff for Prairie Creek Conservation Cemetery. And we talk about a lot of things, but one of them that's always sort of a given agenda item is there anything that we need to address or review on the conservation easement? That's sort of a part of the reason that we do that. See if I've gotten all my points. I think I have. I can give some examples of our conservation easement that, remember I said that it worked remarkably well, given the fact that we had no real examples of how to do a conservation easement for a burial ground. It's like Jeff said, a lot of things that are normally in a conservation easement, you kind of have to readdress because you're going to directly be in contrast because of the nature of what you're doing. But it certainly can be done. And in our case, we have, it's working really well. There are things in there that there'll be a time when we will amend our conservation easement, even though, as Jeff said, and it's been pointed out, it's not an easy thing to do and it shouldn't be done. But you certainly shouldn't go in and start even talking about doing an easement or an adjustment here, an adjustment there. If there's any amendments, it's usually done where you can make it better, and it's big enough to spend the time on for everyone that needs to do it to make an amendment. And in our case, we have some very big what I would call enhancements that we will eventually make. And one, quite frankly, is we're going to expand and actually have more land under the easement with more enhancements built in. And so the big things, those big enhancements, when we do an amendment in the future, we'll make some minor changes that are really obvious for everyone involved that will benefit everybody. And most of those have to do with interpretation and clarity, because there are things in our easement right now, when I read them, I interpreted it a certain way and I was good with it. It was fine. And we operated it the way that I and others interpreted it. But as time went on and someone else looked at it, they had a different interpretation. And I'm going to read you one thing in our easement to give you a feel for that. It says that there shall be no more than one bench per 300 feet of trail in the property at a given time. Well, to me, I can tell that line right there came from, or something like it, from doing typical conservation easements, because they're talking about a trail, you know, on a piece of property, and the whole bench thing is tied to the trail. But there was nothing said about how many benches in the cemetery and other places. So is the interpretation no other benches anywhere unless on our own trails? And so what we did initially is we converted that to putting benches in the cemetery, but we did it on, well, how many, if we had a bench every 300 feet, we didn't have a bench within 300 feet of another bench. And later someone said, no, that's not what that means. They mean on trails, just what it says. So at any rate, we limit our cemeteries limited to 10 benches. And we're all on the same page on this, because if you're not careful, benches turn into memorial structures, and you see them, instead of a natural landscape, you see benches everywhere, which is what both the county doesn't want for their land, and it's also what we don't want for the land. So, but, you know, finding a way to clearly have a way to do that, have a formula to do that. Right now, we limit benches over the whole cemetery, which is 93 acres, to 10 benches, and that's working. But we will eventually have better language that's clear and precise about that, whether it be 10 or 20. So I think I am, oh, there's one more slide. Yeah,
Yep.
Very quickly. This is just, and this is, by the way, it's not accurate now, because this is to show sort of the process that was gone through to create the easement. And this was like one of the early documents. So you have in conservation easements, you have the landowner, which is, correct me if I'm wrong, Jeff, but generally that's called in the easement the grantor. And then you have the other party that's called the grantee. In our case,
Correct.
it's the county. So the county would be the grantee and the landowner would be the grantor. But if you take a look at this, it depicts early on how, and we have something like this now that is more exact, but it depicts a conceptual map of where things are. And you can read some of this, like it has, which is accurate. It has a building envelope there that shows if we're going to build anything in the cemetery, the easement says you build it in this envelope. And you know, where I mentioned 10 benches, well, we could put a few more benches in there, but they would have to be in that building envelope, and they would be probably treated as a certain percent of our 3,000 square foot allowance of building anything. It just so happens we haven't built anything in there, but we still could, according to the easement, if we wanted to put a $3,000 pavilion in there for folks to get in and out of the rain and have some kind of ceremony, we could do that according to the easement. But we couldn't do it further north in the cemetery. It would have to be in the envelope. And it also shows you where trails are and where border lines are. There's, you know, when you have a wetland, there's going to be, depending on your state and county and your easement, the easement could be different. In our case, I think we follow county guidelines, but wherever we have water easements, we have buffer zones of 75 feet that we can't do burials within that, or certainly can't build anything within that. We have, in our case, due to our scientific that we paid for evaluation of water levels, we only have about 30 acres out of that 90, well, I should say out of 78 acres that we actually can do burials on. And if you look at this map, you can see that sort of shaded yellow area. Those are where we can do burials. The rest of that land, and this goes back to what Jeff was saying, we're more in line with 100 burials per acre. average over the whole cemetery. So very low density. Whereas the burial concerns, their limit would be 300. But our easement, pretty much, we're in line with our easement in terms of overall capacity. But there's also, besides overall capacity, there's actual area limitations. We have to be within those areas, and we can't be, we have to be within 50 feet of border lines. That's the big red line. So we can't do anything in that 50-foot buffer. And so all of these things are critically important for everyone that has anything to do with operations. And it's really nice for board members. As many people affiliated with the cemetery should know the easement. Okay, I better quit. We got questions.
So if you want to get in touch with us, here's our contact information. Happy to address any further comments after this. I think we can open it up to questions at this point.
Thanks, Jeff. Thanks, Freddie. I'm gonna dive into the chat here, see what has come up. Let me get there. So early on, Brooke was asking if you could speak about the perpetuity fund that was needed to set up a public green burial space.
Yeah, I can speak to that. And Jeff can speak more to it. I think he's in the process of figuring that out too. But first of all, there's two different things. And one is, particularly in regard to conservation easements, land trust or whoever's going to typically want what's called, correct me if I'm wrong, Jeff, but it's going to be a stewardship endowment. Is that right?
Correct.
And that is different than, but related to what I would call something like a perpetual care fund. And most states are going to require any fully licensed cemetery to have a process in guaranteeing a perpetual care fund. Like, that one reason so many cemeteries across the country are abandoned one reason is because they didn't have an endowment fund to care for them after so many decades. And so it just kind of got dilapidated and abandoned. So it's a good thing that the state does that. And you have to realize states are different. Every state's not going to be anywhere near the same, but that is something that in Prairie Creek Conservation Cemetery's case, again, we chose an avenue that's called an exempt in the state of Florida that allowed us not to have to do that. But of course, we recognized and as a part of our certification that we had to do that. But I would much rather, in our case, we made that choice because we didn't want to do it necessarily with state oversight. So in our case, we had this choice, we took it, but we also set up actually at least as much, if not stronger than what the state required. And that fund, we call that our perpetual care fund for Prairie Creek Conservation Cemetery. It does not matter whether Conservation Burial Inc., that nonprofit, has that in their coffers or whether Alachua Conservation Trust has it in their coffers. As far as we're concerned, it's for Prairie Creek Conservation Cemetery alone. And we have that, which right now is probably in the ballpark of a few, like between $200,000 and $300,000, but it's constantly building. And our goal would be somewhere between $700,000 and $1 million. All right, so that's one thing. And that, in the case of Prairie Creek Conservation Cemetery, part of that would actually be used almost for certain as a part of the stewardship endowment. But Alachua Conservation Trust probably has a certain much lower amount set aside just on their side for that part of their land, since they're the landowner. They have their own policies they have to have, and we have our. So I think in terms of a state mandated perpetual care fund, which I'm pretty sure most states are going to have something, you just got to look at the state statutes and do it like they say, you know, and that's the only thing I can say about it. Jeff, you have others?
Well, yeah, I actually want to pause us on this for a minute, because I think we're going to try and devote a series of webinars next year to the intricacies of perpetual care, endowment care,
Okay.
and financial planning. So hang in there, everybody. We'll get into much more detail on this. We realize that's so complex, it needs more than just a webinar. Let's see what else is happening in
Wait,
the
Jody,
conservation.
let me just say one thing.
Yeah.
I'm not going to talk about perpetual care. I'm going to talk about the stewardship endowment.
Great.
The purpose of the stewardship endowment is to fund the land trust being able to monitor that property every year, or whatever the rate at which they'll be monitoring. Sometimes it's twice a year, sometimes it's every year, sometimes it's something else. But regardless, that money is really, it's a fund that's actually held by the land trust specifically to set aside so that they can fund an individual during the time that is monitoring is required. And so they themselves have created an endowment to be able to do this. That will all of their properties, or definitely all of their easement properties, will have something like this. County governments and city and state and federal governments do not necessarily require, in fact, I know very few that do require any form of stewardship endowment to be set aside. They usually fund monitoring through their annual budget appropriations, but for land trusts, it's almost a sure thing that you will have to deal with some kind of easement monitoring.
Thank you, Jeff.
Okay.
That's great. All right, so Mel had a question. Where do you place the terms of easement for public review? Sounds like she found it difficult to find easement languages when pulling land deeds. Finding land lots with conservation easements primarily as a result from cluster developments, and often I cannot find the easement tied to the land deed.
That's really dependent state by state. And how land records are kept. I mean, I know in North Carolina, it's pretty straightforward to find deeds. When you're buying a piece of land, all of those, the deed or a conservation easement is a deed restriction. So the lawyers will find it as part of their title search process. So it is just really, you might have to ask a paralegal or someone who's very experienced in your particular area on how to find conservation easements related to a particular piece of property, but it's doable. It's definitely doable. That being said, a public review, they're publicly accessible. So you can probably, I know in North Carolina, I can look up any conservation easement that I want. That just by going into the land records of that particular county. Some of these things are handled a little bit different state by state, in some cases county by county, whoever is holding the land records, and that can be challenging. So there are counties, for example, where you can't do this work online. You still have to physically go there and go into the land records and actually pull the individual deed that's there. But it should be all recorded. An easement that should be recorded with some public entity to be enforceable over time.
Thanks, Jeff. All right, next question. The Conservation Commission that hosts the right-of-way and easement monitors has open access to life forest, but that schedule is not written into the easement, aka the amount of scheduled visits. Is the monitoring schedule normally written into the easement?
No, not necessarily. It's usually it's usually the easement allows for the right for the conservation organization to enter the property to monitor. But it's not necessarily defined within the easement. In fact, in a lot of cases, you really wouldn't want to define it because it could change over time. And that's the thing is when you put something in the easement, it's not going to change. So if you say we're going to go there 5 times a year, you have to go there 5 times a year. So usually it's you step back and you say, we have the right to go there. And then you define how frequently you're going to do that. And then you negotiate or you really communicate between the two parties. We're coming out, we do our monitoring in the wintertime because there's fewer bugs and blah, blah, blah. And here's our schedule. Or, or the leaves are down. We can see the property lines much easier in the wintertime. So we'll do that. And then they will schedule a site visit. You don't always have physical, you're not always required to physically be there when they monitor, but it's a really smart thing to do, both to see what they see, because sometimes I'll tell you the monitors actually find problems that occur on your property from the neighbors. So it's really, really beneficial to go, but it's also about building relationships in the community between your tie, the bond that ties you together. You really want to build that and keep that strong, because when you do have an issue, they're not only there to tell you what you're doing wrong, they're there to back you up when someone does something on your property too. And so the stronger your relationship is, the stronger your bond is, they're going to fight for you as the monitor of your easement. And by going every year, they can say, well, I was here last year, this wasn't here. And this building that's now been built across the property line wasn't there last year, you need to remove it. And they'll get involved. So it's really critical that those relationships occur.
Wonderful. Another question, do you provide a copy of your easement to your families? We keep a copy on file with the local planning commission as well as our deed record of burials. Is that appropriate to hand that information via PDF or download on your website?
I assume that's a question to me. Is that?
Sure.
Again, yeah, I mean, we don't automatically, our conservation easement's pretty detailed, and the language, most people don't have an interest in observing it or reading it. We don't routinely hand it out, but if somebody asked for it, we certainly would. And it is in our records, and folks, there are folks that have asked for it, but for the most part, what I have seen for sure is that people ask the question, this happens probably several times a month. I will give a tour, and one of the questions is how can we be sure? We love what you're doing and we see it, but how do we know that someone's not going to come in here and develop this, or eminent domain's not going to come in and build a road through here? How can we be sure? And that is where, I explain the conservation easement, and normally they are just so relieved to hear that. And it makes a huge difference for them to hear that. And that's all they want to know. They don't ask, well, I want to read that. They just want to hear it from you. I hope that answers the question.
Great, thanks, Freddie. Jarrett had a couple of questions. One was about, do the tax benefits that normally accrue to private landowners that agree to an open space easement through a land trust change with the cemetery element?
Yeah, it's a good question. It kind of, there's two pieces to this. One is if the owner of the property is a nonprofit, there is no tax advantage for that nonprofit in donating the conservation easement. So so any monetary tax implications related to conservation burial grounds would only be available for a for-profit entity or private organization, depending on your state rights. The determinant on the value of that, the tax benefit is going to be almost wholly determined by an appraisal. An appraiser is going to review the conditions of the easement, just like they would for any other conservation easement. You've just retained one more operating right, which is that of a cemetery. I asked, this is a really good question that it's, there aren't many of these out there, right? There's not a huge list of like experience. There's not a huge level of experience on these. I asked an appraiser this question a couple of years ago, and he told me that he felt like the reserved rights of the cemetery, especially if they're going to be occurring over, say, a 60 to 100-year period, as the cemetery is operating over time, that wouldn't have a significant, or it wouldn't take away from the value of that property very significantly. So in essence, what he was saying was it wouldn't have, it would have some impact, but not a huge impact on the value of the property itself.
Thanks, Jeff. Another question, once all the interments take place on a conservation burial site, are there continuing operating expenses? If the purpose is to leave the land in its natural state, I'm wondering whether trails et cetera, need to be maintained.
Yeah, I think Jeff can speak to that too, but in terms of Prairie Creek, particularly, I think this is true no matter what, but I can say particularly in terms of Alachua County, who holds the easement, one reason they were so interested in being holding the easement and being a partner in this project is because that county department the easement with is a part of what CARES money pay a percentage of local sales tax goes for our local, it's called a Florida Forever fund. And the whole purpose of that is to have county recreational and conservation land. So they're one of their prime reasons for doing it is so that there's trails for the public to use for hiking and biking, for that area to be available for passive recreation. And of course, our ACT's involvement for the whole intent is for it to be a living memorial. And just like the easement is forever, that is also forever a very much like a nature park that's protected and managed as at a high level for a healthy ecosystem. And that's where, cleaning air, cleaning water, people enjoying it, not only as a sacred burial ground, but also as a way to connect with nature. So yes, that is a part of what that whole perpetual care fund is all about. Another part might be to have, like a part-time, what do you call those people? A part-time attendant who occasionally helps people at certain hours of the day, or is available to show someone at a certain time of day where a loved one is that they've never seen or visited before. So yeah, so it's going to be less intensive in terms of expenditures for sure, because of all the things you're not doing. But there's some things that just keep going, and that's a part of having a cemetery, and particularly a conservation burial ground with trails and other things. So,
thanks, Freddie. All right, here's a question from Mo. What are some more examples of conflicting operations of burial with conservation easements? And could you speak to how you have worked with them to find the win-win situation? For instance, the digging mining restriction or addition of an access road, or how about restriction on structures?
Great. Well, most things in my experience with our conservation easement is we all were on the same page. Alachua Conservation Trust, the county, and certainly our organization, Conservation Burial Ground. We all, it's like Jeff said, we had the harmony overall we had. The challenge is to work out the details that's within that harmony. It's like we all want, the same thing overall. So a good example is the digging of the graves. Well, that's a fairly easy one to take care of. It's like, okay, given that normally you wouldn't want this digging because it's impactful to the earth, well, let us resolve the fact that that impact is hugely offset because somewhere else, for this person that chose burial, they're going to do it with a vault, a metal casket, and embalming. So even though it might not be this earth, it's a method that we're eliminating, and we're giving people a choice. That when they hear that, that means something. And it also is helpful when you talk about, well, one of the things we're willing to do this at a density that is in harmony with nature. And so you basically start to talk about how you're going to do what you all have agreed is a good model, a good combination: natural burial, land conservation. You're past that. Now you're working out the details. And density is one. How deep you dig is another. How close to legacy trees you are is another. We have a restriction on that of 15 feet if it's a legacy tree over a certain size. And we have to figure that out. So you just get there. That's a part of the process. But if you're starting on the same page, you'll eventually get there. Yeah.
Yeah. Jeff, do you have any other thoughts to chime in on this one?
No, I mean, the list of things is pretty large. Species impact on the other sensitive areas, roads, impervious surfaces, fill dirt, buildings. It's a large list, and it's all measured on the conservation values of the property. So it comes back to that point that I brought up in the very, very beginning, and that's this place where you're going to find this intersection of collision points between protection of the property for conservation purposes and the desired use as a conservation cemetery. And quite honestly, there will be times where what you want to do is really not going to be fitting with what the land trust is interested in, in terms of the conservation values. And you're going to have to work your way through that, or you're going to run up against municipal buffer requirements, or endangered species regulations, or wellheads. If you can't bury, like in Massachusetts, you can't bury within 750 feet of a wellhead. Well, that takes out a large area, right? And these are just all things that you have to fit into whether you can or can't do it based on what the rules are, or what the partner is willing to put up with.
Thank you. All right, from Bethany, has working with the county ever become cumbersome? I wonder if that's for you, Freddie.
It really has not. I mean, there again, we all started on the same page. We have found things in the easement, not big things, but that are more clarity and interpretation related, and eventually those will be clarified. In the meantime, we might have a conversation and let them know how we interpreted it. And that's what we're doing for now. And we, agree to, at some point in time, correct it, but not until we have a lot more to do at the same time. But we've really, okay, I just thought of one. We did some land management, and one of the things we do is we plant trees, but we also take trees down, particularly trees that are fast growing. Sometimes in the forestry world, they're called the weeds of trees. In our area, those are often, they're still native trees, but they're like water oaks or laurel oaks. And they came about due to land impact years ago. And these trees grow really fast. They're not longevity. They don't have as much longevity as many of the other trees. And so they've taken over some parts where we want to plant trees like live oaks or hickory trees or other kind of oaks. And so we will cut those trees down, and we cut a fair amount of laurel oaks and live oaks, which in our easement, by the way, says we can do. It says that's one tree that they understand. They say you can cut those if you need to for land management. And we made this big pile, wood pile, that we were just going to let go back to the earth. And we had it in the cemetery. And there's nothing in our easement that really says we can't do that. But on one of their checks, one of the county checks, they said, we don't want those kind of piles on any of our public property. You know, we just don't want it. And so we had to move it. But it was pretty straightforward, and we don't do that anymore, because once you move a big pile like that, you're not interested in doing it again. So that was one thing I could think of, but mostly nothing, nothing that I can think of where we had sort of a breakdown in relationship, or they're really feel like they're not on the same page with us. Every kind of embracing the concept of what we do is probably more appreciated now than it ever was. And that's one of the things that happens with conservation burial. Eventually, whether it be a land trust or a county or whatever, eventually somebody that works in that realm is going to be a family member in your cemetery. And they're going to, if you're doing things right, they're going to learn how special that is. And they're going to have a great appreciation for you. And it makes the relationships even stronger. Same thing happens with donations. If you're a partner, regardless of what kind of formula you have sharing funds, just the fact that you're working together on this, both parties are eventually going to get attention, and people are going to want to help support you as nonprofits. I'm speaking of, really.
Thanks, Freddie.
So Jodie, can I point out one thing? And I think this is an important point. The conservation easement does not give the right to the grantee, the holder of the easement, doesn't give them the right to tell you how to manage your land. And really, the story that Freddie just told is, I think they were overstepping their bounds personally. But so a land trust, in fact, they don't want the right to be able to tell you how to manage your land. It's a conflict with them being able, once they tell you and they're actively telling you how to manage your land, they're really kind of entering a space that makes their monitoring of the easement a lot more challenging, and legally it puts them on a riskier ground. So it's really you as the owner are the manager of the property. You make the decisions. Your decisions need to fit within what is allowed by the easement itself. You can ask them those kinds of questions, but they can't tell you to operate it a certain way or manage it a certain way. They're not really supposed to be able to do that. So it seems like a fine point, but it's actually a really important point. And the responsibility of management ultimately falls on the owner of the land.
Thank you for that, Jeff. Yeah, that's important. Whoops, sorry about my scrolling problem. Susan is pointing out that there was a photo that looked like a controlled burn in the slideshow, and she's curious about who initiates that, whether that's Prairie Creek or the county or the land trust.
Yeah, that's a good question. And it actually goes right back to what Jeff just said. And in the example I gave, it was, as I said, we could have argued with them and probably won, but because of our relationship, it's just not worth it. And I think part of the whole purpose of the conservation easement with the county is for the public to have access, and how that experience for the public is. But in terms of burns, that's a part of our land management choices, and it's well explained in our policies and materials. And that is a part of the project of Alachua Conservation Trust and Conservation Burial Inc. And we do that, we coordinate those together. ACT has the most experience at doing burns, but our organization and our staff, we have the most experience on trying to figure out how to do that in terms of how much at one time and when it's to be done, how to prepare the public for it, how to educate the public about it. So we do it together. The actively burn part is mostly ACT, unless some of our folks just particularly want to help with it or something. But the county has nothing to do with that.
Great. Thanks, Freddie. Another question from Susan. Besides the initial stewardship endowment, is the county compensated? Example, a percentage of plot sales, or is I think she's meaning the conservation trust. Sorry, not the county, CT, but let me repeat it. You got it?
Yeah, I think I got it. I can eliminate either one. The county, as I said before, it's a part of their, they wanted to buy the land to be a part of Alachua County forever to begin with. And what happened eventually is they did the conservation easement and saved the county taxpayer money, because they actually paid ACT some money to have that. Instead of buying the land from them, they made an arrangement with ACT to pay them some money so that it would be public access and a conservation burial ground for the community. So there again, it was a win-win. But as far as ACT and our partnership, we do not have anything in our partnership for, and this gets a bit technical, which I won't go into, but our organization is actually a 501c13, which is a conservation, or which is a nonprofit cemetery or burial ground. And the technicality of that, and to begin with, we just never had there was never any formula for shared revenue directly from the burials. However, what we do is we have an agreement between ACT and CBI where we do share costs, and CBI, our operation, pays ACT for certain services, for certain, for instance, if we pay them to manage the roads, we pay them anything in the cemetery, we cover that expense, even though it's their land. And we also pay them for services. For instance, there have been times when their personnel or employees they had challenging situations where they might lose them, and they did tasks and services for us, which we paid them for. So, and as I said before, both organizations benefit through gaining with community and donations and I guess PR, public relations. So I hope that answers it.
Yeah, thanks.
There is one, as far as I know, there's only one cemetery that actually does have a financial relationship between the land trust and the cemetery. That's Carolina Memorial Sanctuary, and Conserving Carolina is the land trust. And there's a 1% of sales paid to Conserving Carolina from the cemetery for each sale, except if the land trust brings customers to the cemetery, then it's a higher number. So that's the only one that I know that's actual structured and fixed and operating at this time.
Thanks, Jeff. So I want to do a quick time check. It's a little bit before 1:30. This is a really great conversation, and we just keep getting more questions added to the chat. So I'm inclined that we keep going, but I want to offer and respect everybody's timing, and to remind folks that I will send a link to the YouTube version of this offering once I upload it. And so if you need to leave, you can come back and check on check on the nine new questions later. All right, moving along. From Mo, my question is coming from working with oh yes, this is Mo's earlier question about conflict is coming from working with an existing conservation easement on the land. And so that would maybe be a question about how to be in harmony with amendments to the easement.
I'm going to be really blunt here. If I were a land trust and someone came to me saying that they wanted rights that didn't exist because the easement was already had restricted away the ability to, for example, dig holes on the land, as the land trust, I would probably say no, and that would be the end of that. It's harsh, but that, don't be surprised if that's not the case. The point of amendments, quite honestly, is supposed to be that what you're bringing to the table actually improves the conservation values of the easement, as opposed to diminishes the conservation values of the easement. So as Freddie pointed out, you're putting more land under easement, or you're restricting things further. And so that amendment would be something that would be considered. But weakening an easement is very rarely done. And quite honestly, if there was any tax benefit that was given for that easement whatsoever, then it's forbidden. The IRS can come knocking on your door and make your life a living nightmare, because someone has actually gotten money, tax benefit, for that easement given up. So it's a real challenge. There probably are, but as I said, if you can make the easement alterations improve the conservation value, then you have a real greater chance of getting an amendment.
Okay, thank you. Jarrett's asking, are there any conservation burial grounds that restrict public access entirely, except perhaps to descendants of those interred there? In our area, the preponderance of land trust activity is to protect sensitive land from human intrusion.
There's nothing that in most states, there's nothing that requires you to provide public access. One of the rights that I mentioned earlier about owning land is the ability to restrict people from your land. So if the easement states that there must be public access allowed, then you've taken away your ability to have privacy. But in many cases, you can restrict people from your land, and theoretically, a cemetery could restrict someone from its land. I'm not sure it wants to, but we're talking in hypotheticals here on whether it's possible. The answer is yes. Whether it's practical and whether it's the kind of thing that's going to endear you to the community, probably not.
Well said, Jeff. Yes. Let's see here. Oops, I'm going the wrong way again. Penfield needed to leave because there's a storm coming. For Freddie, this is from Jarrett. Does the county get any revenue from your burial ground? We did maybe have covered that already. Did the county raise any concern that involvement with your project would place it in competition with the traditional funeral industry in your community?
That's an easy one. The answer is no, they did not. But I mean, early on, which I recommend for everyone, we made presentations to all the county commissioners, explaining what we were doing, all the benefits. We went to community where the land is. The community had at least a couple meetings of all the neighbors and explained what we did. We dissolved a lot of, what do you call those, rumors or, non-truths. We did, that's something you got to do, absolutely. Otherwise, you'll end up with a roadblock. So, but the answer is no. And I'll just for the moment also use this minute just to say, once again, remind everybody that, you know, conservation easements are not cookie cutter, even though there's a lot of benefits to look at others. It really boils down to what you and whoever you're dealing with is that conversation of making sure they understand all the benefits of the concept and the model, and them making sure you understand where they're coming from. And so they're very much an individual thing. So
Thanks, Freddie. How often does your easement agreement require reviewing or amending between the parties? And then also curious why $700,000 to $800,000 endowment with such limited costs. Is there more to your thinking? And that may be a question that we pick up in further detail in future webinars when we're talking about more endowment specific things. But to go back, how often does the easement agreement require reviewing or amending between the parties?
Well, I mean, it's rare to amend easements, so it's the exception. You know, Freddie, I think would perhaps agree that there are exceptions. There are reasons why they're even considering amending it, because they've found that the easement didn't clarify some of the points that need to be further clarification. So this question of benches, the question of you know, does the easement, when it's talking about the number of burials, is it including cremains as one of those burial types? Those kinds of things, when you find points that have not been addressed, then that seems like a rational and reasonable kind of reason to enter into, you know, negotiations or conversations. But as Freddie pointed out, it's always important to kind of keep track of where things stand, how you're operating. Are you operating within the terms of the easement? As I mentioned in the monitoring of the easement, just those annual visits, showing them how you're working, how you're operating, and it might raise points. Or as we all know, climate change would be a great example. The easement might not really adequately give enough ability to deal with invasives, for example, which might be an impact of climate change. Or I don't know, another one would be like water flow has caused a significant amount of breakdown in the you know, one of your hillsides, because, you know, you're getting so much water running down it, and you need to go in there and you need to fix it, and your easement might not allow. There's a perfect example of like, you could never have predicted that maybe 20 years ago, and yet you have to do something about it. So, you know, having that active conversation, the holder of the easement's totally going to get that. They're totally going to understand that, and they're going to work with you to come up with creative solutions, which might include an amendment of the easement if necessary.
Great. Thanks, Jeff. Oh, Susan Greer is chiming in that she thinks that Foxfield also has a financial arrangement with their center. Is that not?
I don't. Well, they do with their center, but that's different. That's different. The land. So what we're talking about, the easement holder in Foxfield is the county. The county has no financial relationship with Foxfield. The Wilderness Center, which is was the original owner of the land, which is now land owned by Foxfield, they have a relationship. One, because Foxfield is a subsidiary organization of the Wilderness Center. It is a 501c13, but also because they're still paying off their debt from originally acquiring it. So their arrangements are, and they have a particular arrangement where the members of the Wilderness Center can get a reduced rate at Foxfield, which is a crafty way of moving revenue from the 501c13 into the parent organization. So it's a little bit different, but it is a financial relationship between.
Yeah, it's the difference of being under an umbrella versus a organization. I mean,
Right.
like you just said, the cemetery is a part of, under a subsidiary of that parent organization, whereas, for example, Prairie Creek is a totally different nonprofit. We're just partnered with the nonprofit Land Trust in Prairie Creek as a project. So yeah, it's different.
Yeah, thanks. Jared's asking, are there any land trusts that have approached conservation burial as a method to improve their own finances, a model in which they supply the land resource in exchange for a revenue share while keeping a totally passive role?
Yes, it's the land trust world is still coming to terms with conservation burial in general. There, but even in the last 2 years, so Heidi and I at Landmatters, we do conservation consulting. So we actually have spoken to several land trusts about this topic, and we've actually presented with others from the CBA have presented at the land trust annual meetings to kind of bring this issue, this new what we can. It's a program. It's a potential program that land trust should really consider, because the mission alignment is so close between what land trusts do and what a conservation cemetery is. And they own land. They're not afraid to own land. They run programs. They're not afraid to run programs. So it seems like a natural fit. But you have to work out a lot of the quirks, and you have to work out a lot of the challenges that come with the risk of taking on a conservation cemetery, which is quite honestly a really big undertaking. That can't be understated. It's a big job, and land trusts in many cases, they'll be. This is just my opinion. They're 80% there, but it's that other 20% that's holding them up, because the risk of impacting their mission, their existing mission, with this new project could be too much of a challenge for them to get over the top.
Thanks, Jeff. I am seeing, I think that was all of the questions in the chat. I'm gonna close this. And yeah, thank you, Bethany. Thanks for joining us, everyone. Let me see if I can get back to everybody's view. Freddie and Jeff, thank you for that brain download. Very, very helpful, and appreciate, as always, the underlying human relationships and communication that is involved in collaborative efforts, and keeping harmony as a focus with this. Any other thoughts for the good of the order? All right. Yay.
Thank you very much.
Thanks everybody for taking this time. And like I said, I'll follow up with an email with the YouTube link, so you can revisit any pieces that may need clarification in your brains later, or share with folks who this might help move your momentum along.
Thank you, Jody.
Yeah.
Thanks for helping us.
Thanks, Jody. Thank you.
Absolutely.
Thanks, everybody.
Take care, all.
Thank you all. Take
Thank
care.
you. Take care. Bye-bye.
Bye-bye.
Bye.